Gang. And we gonna see. All right, I see it's going up. Okay, so we up, bro. We all the way live, and we definitely not crabbing. So we are in the building. Hopefully everything will go smooth like silks. And what it do.
The duo, the dynamic duo, once again.
Yeah, who Batman and who Robin? Hey, anyway, man, yo, peace, y'all. Baragani Islam, Salam, Hetepu, Rahubat, Gino Lakuni Nani, Chief Noble Bandele El Amin back in the building. And once again, I got my partner in crime, King El Bay, is in the building. So
Yes,
give it
yes,
up.
yes, y'all. We back.
Yeah.
We're gonna talk about this business tonight. Get some folks some
Yeah, man.
understanding.
If y'all got a house and got a mortgage, or if you got a student loan, we gonna get into it tonight. Cause for real, they really one and the same. But anyway, so let's get into this, y'all. Um, Before we get into this, y'all, please like this video, subscribe to the channel, and hit the notification bell. All right, so smash that like button, and also check out all of my books on Amazon.com. Oh, let me go to it real quick. Check them all out. We got Morris Treaties, and then we got, if y'all got the first Morris Treaty book, man, we got the second Morris Treaty book too. Okay, so we got Morris More by Man, Birth Certificates Explained. We got Morris Treaties 2. Okay, Nationality Birthright. We got the Holy Quran from the Morris New Kemet, Indigenous Manuals. Get this journal, y'all. If y'all need a journal to write down these notes that we be giving, all these lessons we be giving, y'all need a journal. Get this journal. All right. And also, if y'all planning to get married, this is a great guide to the religious marriage, alternative to the civic marriage. All right. So let's get on in the building. All right. So enough said about that. All right. So um, let's get into it. We like I said, tonight uh, we're gonna be talking about mortgages. You know what they mean, and also we're gonna talk about student loans because uh, people don't really people don't really know that student loans and house mortgages, they kind of have a relationship. Okay, they kind of have a relationship. So we're gonna get into it. I did a video. I did a video before, and we talked about the promissory note. You know, we broke it down from a dictionary standpoint, from the Black law standpoint. You know, we broke down how the promissory note is really other things. Okay, so I mean, like if y'all really want to get into it, y'all can watch that video. Okay, it should something on student loans. It's on promissory notes, right? But I talked about that. And that was like, man, almost 10 years ago, right? Or maybe 10 years ago. And you know, back then I was saying that at some point, you know, soon that student loan was going to be a major problem, and it's very interesting. Y'all can see that I said that, you know, I said that years ago. So I'm not just saying that now. You know what I mean? But the fact that uh the promissory note, I mean, that whole student loan thing is just like the housing market. You know, when that housing bubble, you know, I talked about the housing bubble and how that it crashed and how the student loans are very similar to it. And, you know, and now we got, you know, jumping Joe Biden out here, and, you know, he's trying to, you know, eliminate some of the debt, which, you know, what is he doing? $10,000 or 20,000? One somewhere in between 10 and 20,000. I do know, and I'm like, man, that's really nothing but a scratch on the surface because you know if y'all got kids and children or whatever children in college now, y'all know how much it costs. And what it really is, the problem is that because of student loans, and they know that they can get this guaranteed money, that they have, they've raised the amount of money for school, and so now, you know, it used to might cost, it probably cost three times what it cost back when I first went to school. Okay, I remember it was like $80. Nah, yeah, like 70 or it was like $70 a credit hour. So I don't know what the credit hour is now, but if y'all know, put it in the comments or leave a comment to say how much a credit hour is. How much it costs for one credit hour in school. All right, because I remember it wasn't nothing, and then it just started going up. You know what I mean? So myself being having to understand student loans and whatnot. So I know and I knew that it had to be something going on with that, and that eventually it was going to, either come to a head. So I think right now, when we seeing with Joe Biden trying to do this is, I mean, he's putting a band-aid on the situation, for real, just enough to kick it down the road so some other president got to deal with it or some other form of government got to deal with it. You know what I mean? So I don't know. I don't know what's really going on with the student loan, but I do know there is something fraudulent going on with the student loans. There is definitely something going on that you guys don't know. Your average person doesn't know. And before we get into all this, right? Before King get back, before we get into this, man, I ain't trying to hear about pay your loan. Pay your loan. I mean, like, you know how many people are in student loan debt and are not able to pay their student loan? Particularly in this time when things are going up, everything going up but your checks, everything going up but your paycheck. So, I mean, for you guys to sit there and say, well, you need to pay your loan, you need to pay your house mortgage, that's how you solve it. I ain't trying to hear y'all clowns, y'all bots up in this mouth. Okay, so that's not what we here to really get an understanding of these agreements that we get ourselves into because we sign contracts all the time and we really don't understand them. Okay, so with that being said, man, I did want to get into the mortgages.
So
I don't know if you ready for it right now.
I'm ready. I want to break this
So
down.
I'm gonna put up on the screen.
Okay, so we got to understand that there's different processes in the mortgage processing. The first agreement is a purchase agreement. First, you got to find an owner of a property that you're going to purchase the property from. You got to realize what you're purchasing. You only purchasing the paperwork. That's technically what you're purchasing.
Hold
So,
up, before you deep dive in there. What is a mortgage, man? Like what can you
well, let's
can you
break it
tell them what a
down.
mortgage is?
I'm gonna go to the conventional way. I like to, like I said, I like to read it off so people can see. I thought I had it pulled up. I must have clicked on it. Okay, I got it. Mortgage. We're
Do
gonna
you got it up? You
a
know,
mortgage. A mortgage is an estate created by a conveyance. absolute in its form, but intended to secure the performance of some act, such as the payment of money and the like by grantor or some other person, and to become void if the act is performed agreeable to the terms prescribed at the time of making such conveyance.
Can you put that on the screen?
Yeah, yeah. Let me put
Now, hey y'all, I want y'all to remember what he said. We're gonna put up on the screen because you're gonna find out that these mortgages and student loans are very similar. That's why we're gonna put it up on the screen. Okay, hold on. Let me add it. My fault. I should add it. It should be popping up in a second. Is it up yet? Because I think my stuff is slow.
it should be up.
Okay, it's up. Go ahead. It's
Okay.
up, sir.
A mortgage, an estate created by a conveyance absolute in its form, but intended to secure the performance of an act, such as payment of money and the like, by grantor. I want y'all to see this says payment of money and the like. What is the like? By the grantor or some other person to become void if the act is performed agreeably to the terms prescribed at the time of making such conveyance.
Yeah,
And then it
that's
has a
that's heavy.
conditional conveyance of land, a transfer of property passing conditionally as secured for a debt. A debt by specialty secured by a pledge of land in which the legal ownership is vested in the creditor, but in which, in equity, the debtor and those claiming under him remain actual owners until debarred by judicial sentence or their own laches.
Okay.
So,
So I wanted that red, man, because I think that's important. It says like, okay, so I mean that first part, an estate created.
right.
So like when we talk about mortgages, I mean what they say the mortgage is an estate.
But this is the thing I want people to understand, right? And this is so tricky in this thing. So we create what they call legal documents, right? It becomes a legal document. Here's the issue. They're practicing legal lease. When you claim that it's a legal document, you give it the vice of legalese and making it intellectual property of the bar because they the only ones that can make legal documents. Do that make
Yeah,
sense?
you saying the bar is the
Right.
one that make the legal documents. So you're saying that once they make legal documents, they're they're
They,
involving the bar.
yeah, their copy is copyright material. So you can't like that's why when lawyers create legal documents, it's actually like it's just like if I went and reprinted Black Law's dictionary, right? I couldn't do that because why? It's a copywritten document. When you claim that it's a legal document, then it's actually a document that you're saying that is legally created through that jurisdiction, through lawyers, through the bar association. So you just really, a lot of people don't understand what they're doing when they start creating legal documents. You see what I'm saying? Versus they make it a contract. It don't have to be a legal document to be a contract. It could just be a contract. It could just
I got you.
it could just be
I
a
got you. So
agreement. So be careful what you title something, because then you are using someone else's intellectual property in which they have the right to get their royalties from. They have a right to lien that, or even cause you to estoppel, to put stop you from using such instrument, because it was created in other of the essence of a legal practitioner, meaning that you use some type of legal verbiage or other things in there to facilitate the construction of the contract. Do that make
okay.
sense?
I mean, y'all, if y'all want to put a comment in there, if you guys are on there, put a comment if you guys understand. If you don't understand, if you're watching this video later, you don't understand, you know,
I
let us
tell
know so we can, take, you can ask questions. You can guys, you can call us and ask questions if you
right.
guys don't understand as well.
So the
So
first thing,
mhm,
okay, what I like to talk about is when we get to talking about a mortgage, a lot of people understand that a mortgage is a dead pledge. It's under a promissory note, but I want people to start distinctively understanding what they have to do when they're doing contracts. So one of the things you have a right to do is inspect the contract. So when you walk in the bank and you already got a purchase agreement from a potential person that's going to sell the home to you, right? You got to understand what you signed, and there's conditions in associated with the purchase agreement. Now you go to the bank, and a lot of times the bank will, if once they get ready to, to settle the claim and being able to do the mortgage agreement, a lot of times you're sitting there with somebody and they're telling you how to go over it. No, you have a right to privacy. And the first thing when you purchase a home, you should elect to go into a room by yourself in private to read over the document. Anything you see in the document you do not like, you can line item veto it with your initials and the date. That'll allow you to modify the contract. Don't let these people tell you what you can and can't do. They don't have no legal authority, especially, I wouldn't even care if they were lawyers. They don't have the right to tell you what terms and conditions and how to bind you up in any contract. That's the first element you should be doing, is inspecting the contract. So that's number one. The second thing is, are you in a contract? What are you in? Is you in an agreement? What did you perform? What did you actually perform? Right? You got to ask yourself, am I in a contract, or did I sign an agreement, or what did I do? A lot of these mortgages, they really tenant or lease agreements. So they'll put you in these agreements and you're just a tenant. And the bank, you become the grantor, they become the grantee, and you grant them over the property. And then what they do is, once you grant them the property, then you become tenant, right? And they then take over the control or ownership of the legal document. So you just signed over your right as grantor, and now they the grantee, and now they become the grantor, and you become the tenant.
Okay.
You're not reading and inspecting the document. You don't understand what's going on in the transaction. So a lot of you, the bank is not signing on these documents. You're the only one signing on the transferring of property. The bank is not. There, you're signing over title to them. So a lot of these mortgages,
Right.
most of them are invalid. No, it's not. It's valid. It's valid. See, the validity. See, a lot of y'all think that it's invalid, but you can transfer property anytime you like. It's Beverly right now. If you want to go out here and transfer his title over to the car to me, he can do it. It's valid. The issue is that we don't inspect and we don't know what to do. That's number two. A lot of us don't understand if we're in a contract or an agreement, we're making a claim. So the bank is giving the owner monies, right? Federal Reserve notes. He says if the note isn't on the record with the county, there isn't a valid contract to the mortgage. You say if the note isn't on, they do file it on the county. Once you get it all together, they will file it on the county. They will file everything, and then you will have to do what they call a satisfaction of debt, and that the county, and they were authenticated. All of that supposed to have been done in the transaction. So what is actually going on? What did you sign, and what in that, and it varies from state to state on and who you're dealing with if you have a claim with the title company. So here's the issue, right? Here's the issue, and I'm gonna break down the primary issues and how to deal with these. So the first one, like I said, you're not inspecting the contract, you're not going off. The second one, a lot of the times you're only the one signing. So a lot of this is an agreement. You're not even in the contract. If there is a contract, then there has to be two parties. And that person that signs the contract has to have the delegation of authority to make the transaction. So, what do that mean? His delegation of authority must be somewhere in the record where he has the right to do what he's doing as it relates to the mortgage. If you're signing it over, if they're acting in a trust capacity, where is his delegation of authority? Where where can you identify that he has the specific right and title to perform the transaction in which he done? That's number three. Number four is a lot of you guys are not looking to determine, even if in pulling the records from the state, you're doing business with a bank. The bank must have a registered agent with the state. Nobody's inspecting to getting the information to determine if they're even registered with the state to even do the transaction, to determine if the state has jurisdiction or not. Nobody even is pulling up from the Secretary of State. You're not asking for specific documents before you sign the contract. You're not determining who they are and what they are as it relates to the mortgage agreement. So he's saying a trust is invalid if it's induced by fraud. So a lot of people want to argue the elements of fraud or the statutes of fraud. That's not going to fly. Most of that is not going to fly because most of you signed the contract and you are in an agreement that you read. This is what y'all signed, that you read and understood the contract. That's what y'all signed to it. So once you sign off and you said that you read and understood everything that you signed, you cannot go back and undo what you done. So let's go to number 5. Let's go to the another element of determining the mortgage to number 5. Do anybody pull the tax records once you've been paying on the mortgage for at least a year or more? Do anybody pull the tax records? Is public information. Do anybody inspect and look at the tax records relating to their property as it relates to what did the bank do, how did they file the taxes on the earnings of the property? This is how you know if somebody's paying taxes. This is how you know if you owe a debt. So if you pull up and you don't ask for the taxes, you don't ask for that because you should be able to get some relief, some tax relief when you purchase the home. So you want to ask the bank, hey, could I see the associated taxes associated with the property? And you will find several things. A lot of times when you own a house, the house would go from title company to title company. You will have multiple title companies that they switch and over the property to. Some of these things you need to read and make sure that those are in the contract. Because if somebody got if let's say your property, you had it for 5 or 6 years and a new title company got it, the original title company can be the only one that can foreclose the property. So if you have a new title company and they're not on there, then they cannot sue you in court because they don't have original jurisdiction based to the fact they're not the original contractors that you have. Let's go on to 6. This is one of the biggest things that go on with this. They fail to have a notary on some of these documents. They and in order for the attorney to sue you in the court, all the all the paperwork that he's present in court is all hearsay. You know why? They must have a witness. The attorney do not have first-hand knowledge. This is how you disrupt. All he doing is representing what the company presented to him. He must have a delegation of authority or be a trustee and must have been a eyewitness to present these matters in the form of an affidavit. If the bank presents a affidavit, it must be with the person who signed the original contract. They the ones who must put in the affidavit. Everybody else cannot be a eyewitness because they was not present. So they cannot move forward on the claim because it will deem all of it would be hearsay evidence to fall under the hearsay evidence rule. And you can hit them with failure to state a claim for relief because due process, you have a right to confront your accuser. The, if the corporation that's accusing you, whoever signed the contract must come forward. Even if he fill out an affidavit, he must tell the attorney, he must come and witness the affidavit or the case is dismissed. Do y'all understand that? Anytime you in court in a civil action, it's all based on an eyewitness. Somebody got to eyewitness that you performed that. So if you say this is not the original contract and they don't have a witness there that says that you signed that contract, then they don't have nobody to testify to the contract itself, then everything is considered hearsay and it won't play out. Don't pay, they'll send you a statement with a negative and a positive number of account of mortgage. So I hear all this stuff all before, right? Don't pay, don't pay, don't pay. And then when people get into court, they don't know how to deal with these matters. So the issue of the matter on the payment and settlement of any debt with a contract is all about performance. So what you got to do is since they what did they loan you? They never gave you no money. So what did they
Nope.
do? So you put it's all about performance. It's one contract for another contract. You gave them an asset called a security, a promissory note, right? To pay for future. So you have to understand what to sign and what not to sign on the promissory note. But the promissory note is considered the asset. This is what get them value because you now they can sell that debt. You just put yourself in bondage because you promised to pay a debt. You promised to pay. So now they can say, I got Willie Lump Lump. He wants to pay this debt of 300,000. So now they can leverage that and take that note and borrow against it. They can sell it. They can sell it. So I'm giving you some tips on a lot of y'all when y'all going to court, what you need to be doing and thinking about these contracts. Y'all not inspecting the contracts. You're not pulling up the taxes. You're not doing anything as it relates to show the validity of a debt. A debt has to exist. Where there is no debt, they must show you where they have took a deficit. They got to show you. And it's going to show on their tax returns. If they get any form of tax credit, if they're not paying any debt to the IRS, then it's not a debt.
Okay. All right. He got one more. My brother GT Entertainment. He got a lot of questions
He
or a
said
lot of
the
statements, I
note,
should say.
he said the note disappeared from a record and they just filed a deed of trust on record because the note hold them liable. And if the note is not bifurcated from the deed of trust, the mortgage is invalid. So I get what he's saying, right? But this is
So
why you ask for discoveries. You ask for a discovery because this is the problem. Most of the time, if you don't inspect it, you can argue if this is what I try to tell people. A promissory note must come with a contract. And this is why. I'm promising to pay you for something. The contract holds the validity of the promissory note of the mortgage agreement. If all the components are not there, then the promissory note cannot be enforced because there was no exchange of anything where no obligation or duty needed to be rendered. So the
I'm trying to figure out how the note just disappeared. Though he's saying the note disappeared from record, and why would the note disappear from record?
because they done sold the note.
Okay, so then when he's saying,
They
so
left
he,
the note.
so he's
They
giving the reasons why. He's saying that these things happen, but he's not necessarily telling us how you're going to deal with it in court because it's still go to court. It's still going to try to pull your bluff, and you can't just go to court and say the note disappeared from the record. You can't explain it. You're going to have to put all this
Yep,
in. You're going to have to file this in court according to the rules of the court.
right. This is why you
He's
got
saying the company.
the company don't
He's saying the
file
title
it.
company.
Then how could they state a claim? Then you got to hit them with failure to state a claim. Because I try to tell people when you dealing with the claim, like I was asking a guy today, I said, "What was the complaint?" He said, "What do you mean?" I said, "When they filed with the court, they had to tell what kind of complaint that what they're saying. They're complaining to the court that something that you didn't do something. So what was in the complaint? He could not tell me. I said, how could you file or rebut something you don't know what they filed? Was it a breach of contract? Was it a breach of fiduciary duty? Was there a breach of any kind? Was there fraud? What did they say in the complaint? Most people don't know what the complaint is over. They say, well, I defaulted on my mortgage. No, what do that mean? That have a specific explanation. You default on your mortgage. What does that mean? What does it mean? It has to be in detail. Law is very specific as to the relationship between the two parties. What is he claiming? Is he claiming himself a debtor or a creditor? Did you give him your social security number? And I'm going to tell you this. Anybody who has the social security number must identify that they have a clearance, a security clearance to even use the social security number because it's a security.
Mm, they don't, and that's not in the contract, or right?
Now people just give up their social security number and
Because they give it for credit. They got
they
to
give
run
it
your credit report.
that that see that's what it wasn't really intended for. So people give it to institutions, and the institution hasn't been cleared by government to have a security clearance to even handle the social security number. All you got to do is go to the website, look at, go to the palms and start combing through, and they will tell you in the sections. And it's also in the United States codes. I can't remember the codes right offhand. And then let me give you another uh, thing that you need to understand. You don't even qualify for a loan if you're not fish farming.
Yeah, break that down because you have mentioned that before. You say you don't qualify for a loan
It's the
unless
loan.
you are
A fish farmer.
a
You're a
fish
fish
farmer.
farmer. A mortgage, you cannot qualify for a mortgage unless you're a fish farmer. So you got to look at everything as it relates to law. So if they say there was a breach or of any kind that you defaulted, they are operating in the capacity in which they cannot operate. So the first thing you these promissory notes that you sign, they must be attached to a contract to perform to identify what you were supposed to pay them with. Because if you signed the document, right, and they created a security off of that to get monies, they can't ask you for something that wasn't that wasn't generated from the beginning. So if I give you gold and I want my payment back in gold, but if I give you paper, then the only way you have to pay me back is in paper. Really, it's with a contract. And what
And
most people,
GT Entertainment, if you want to pop on this, if you want to come in, you got anything to really talk about, you can join the you can join in if you want.
come on, join in.
We have no problem with that. Join in. You can you know y'all can have the dialogue so there can be some understanding. Because from what it sounds like, you saying some stuff and it's an agreement, and so coming together to show how to actually put that uh, into workings. Because a lot of times we got all this information, but we don't know how to convey it to the court. You know, because that's the key is the communication, how to communicate this with the court. You know what I'm saying? Which is cool. That's fine, brother. I'm extending the invitation to you or anybody else that want to come in to talk about it. Okay, so it's no big deal. I just want y'all to, have your opportunity to be heard. That's all. So, go ahead, bro. Uh, you can go ahead and continue. Keep on talking, bro.
So I'm just trying.
Brother Keith.
I'm trying to pull up the section of fish farm credit lending.
Yeah, right. We saying now. Check this out, y'all. He's saying that y'all can't even get a loan. We not even supposed to be getting loans unless we fish farming. Now that's crazy. Who ever heard of that? Who ever heard of that? And peace, God, peace 8.0. Brother Jamil in the building. We got to do a show, bro. We need to do a show, brother Jamil. And if y'all, smash the like button and subscribe to the channel if you guys are new. Please do. We got a lot of other videos I can check out, but
And get
smash the like button. We need as many likes as we possibly can get so we can keep bringing more stuff. because the rabbit hole deep. And like I said, we ain't even gotten into the promissory notes with the student loans. See, because Kane talking about promissory notes with this mortgages, but hey, the same thing applied to student loans. And we gonna get into that. We gonna get busy because all these
So
niggas out here with these student loans.
we're gonna
Yeah,
look at we're gonna look at some of this stuff as it relates to um, mortgage loans and administration of escrow. But I'm trying to pull up that falls under this. Why I don't want to
it's not.
pull
And
up.
you saying that you saying the fact that these loans are not supposed to be made unless you're a fish farmer. How in the hell? How is that even relate? Like how? Like when they build houses? What are they supposed to be doing? Like when you get a house, what are you? What are we supposed to be doing when we get a house?
But that's the problem. So let's go to. Let me see. Can I share the screen?
Yeah, it's not up yet. It's not up for me to share.
Okay, let me try to share the screen. Trying to see. Can you see it yet?
Yeah, it popped up. It should be popping up on the screen. You.
You see this mortgage trustee, commercial fishing and agricultural bank established pursuant to state law, commercial lending organized under the laws of the United States or of a state and eligible to own a vessel under 46 USC or a mortgage trustee that complies with the requirements of 46 CFR. And
Okay.
they try to get all of this for this, but they're doing admiralty maritime law. They brought the law
Oh,
on the land.
not the maritime, not the maritime. Right. We stay in maritime. So they're using maritime law on
Right?
mortgages.
Mortgages.
Okay,
Because
now break that down again.
so
how they using maritime, y'all?
they they brought the law. So Congress, right? You got to understand that this is a congressional jurisdiction. Congress write the laws. So you got to look at what is Congress in control over. It's all military. It's all of the naval. It's naval in nature. So it's admiralty, maritime jurisdiction as it relates to the law of contract and the law of the sea. So a lot of these contracts that we're getting in for this is why they always change. They'll take a car um, and take that and change it into an automobile. They would take all of these
You mean take a
terms.
car and make it a vehicle, a
Yeah, make
motor
it
vehicle?
a motor vehicle. They would take these terms and reconstruct the terms. They associate the term with the jurisdiction. So long as you identify with such term as it relates to the jurisdiction, you're in the jurisdiction. So this is how that works. Subject matter jurisdiction. It's all defined by the terms and conditions. So a lot of us do not look at all of this. So we got to look if it's a first you like I said, nobody is going to the Secretary of State and pulling that entity up to determine the LLC, what kind of entity is it that's registered to the state? then they don't even then because once you find out who who registered in the state, now you can make a determination if it's filed, if it's a trust associated to their corporation, and pull up that. And then it has to adopt particular laws in order to be able to do what it's doing in the form of a mortgage agreement. They have to list the statutes that is incorporated for them to be able to perform the service. So now you can start looking not only at the corporation and with everything they're doing associated with their bylaws, but you can pull up the registered agent and determine if there's a trust involved, who the bylaws. Now you can get all into the affairs of that trust. Does that make sense?
Okay.
So now you can
Okay.
see if they're operating within federal guidelines. They could be even compliant with state, but in order to do business in the state, doing mortgages, they still there are certain federal guidelines that they need to ensure that they have adopted and incorporated so that they can be in compliance with federal and state law. And nobody is pulling it up. They're not pulling up their taxes. They're not doing all the different things in order to dispute the claim. Most of the time, the lawyers show up. There is no party there. The bank is not there. They're not having. They don't have a person. Don't have all his delegations of authority to even speak and identify himself on the record to say that he has a right to do everything that he had the right to sign off on the contract, because the only thing the lawyer is doing is representing all the contracts. So if the parties are not there, everything the lawyer done is in vain, is considered hearsay, and you ask for a motion to dismiss on the basis of the hearsay rule standard, and that they failure to state a claim in which relief can be granted.
Okay. Okay. I hope everybody taking note with that. Um, so I do have a question though. What is the bank's part in the mortgage? Can you explain that to everybody's
Bank is
understanding?
what they call the intermediators, right? So this is what the bank does. They are accessing the account for you because you don't have the licensing requirement as a broker to amend or license your own security. So the bank is the one who has the license. They can mortgage, they can get the money for your securities, which is from that is licensed material, in which you have to have that kind of that have a some that kind of broker's license to broker a deal for your social security and your birth records. You got to have a broker's license, and the bank is an intermediary that can do that for you.
Okay. What you think about uh,
They
Brother
usually
GT?
sign affidavit saying they are exempt from licensing requirement under state law. What about federal? What about federal? I mean, before they can do anything in the state, they must be aligned with federal law. Federal
Right.
law Everything comes from the feds. The Constitution is a federal statute. It's all
Right. Federal
federal.
documents.
All of this stuff is birthed from the federal level. The feds gave the states, they granted them their jurisdiction. They were all granted their jurisdiction.
Right.
So even with the if even if they say this, right, the bottom line is two things got to happen. They got to have somebody authenticate that said you the one who signed the contract, and then they got to have someone that say they signed the contract. And normally, a lot of those people don't even show up. Who showed up and said, "Yep, he signed the contract"? All you
Who's
got
gonna
to
show up and say that?
Yeah, all you got to do is say, show me where I signed the contract. And he gonna pull up and say, didn't you sign this right here? Isn't this
Right.
your signature? And you say, I don't remember signing that, sir.
Right. He said they have a notary there.
The notary, so the
I mean,
notary,
I mean because they gonna try to cover they gonna try to cover their backside.
the
Like they're not
notary,
gonna just.
the only person that can authenticate the record is you and the notary.
I got you.
The the
Let's
the
see.
the, the prosec the not the prosecutor, the attorney. If they turn in a promissory note,
Yeah, I
who
want to.
who is the other party that came and testified and said you signed the promissory note? Because anything the attorney does is hearsay. That's why everything has to be in the form of an affidavit. There always must be a witness.
Right. They be doing that robo signing. And see, this kind of lead me right into like the whole thing because these promissory notes are used with the student loans, right?
Right?
But like you were saying, a promissory notes are often they're securities. And so like right here, even like right here is talking about that typically. So y'all don't understand. Like when we get a student loan too, promissory note, just like you're doing with a mortgage. And then when you do that, it's like they say right here, like we ain't making this up. This is off of a law site. It says typically when promissory notes are offered to the public, investors are not informed. You hear that? They are not informed that the promissory note is a security. Yet, under American law, specifically the Security Exchange Act of 1934, has many promissory notes qualify as securities. So you see that that's back in 1934. We're not even gonna get into that, but that sounds like it's right around the same time when all the money, everything changed with the money. Okay, but then it says right here that this further is clarified by a Supreme Court case in 1990, the case of Reeves versus Ernest and Young. In that case, the court noted that all corporate based notes that have a maturity time in excess of 9 months are presumed to be securities. Yet, despite being securities, many promissory notes are, look, unlawfully offered by non registered individuals outside industry regulations. Okay. So, right there, it goes back to what we were saying about having to inspect the information. Like if you've defaulted on your loan If you've defaulted on your mortgage or your student loan, and they're trying to get their money, then you have to inspect the evidence, like he's saying. You have to have inspections on that evidence. I know that when I was helping with the student loan person, I'm doing an investigation. So I'm trying to find the loan. I went back to the school of the loan. I asked them, where is the loan? They said, we don't have it anymore. They said that a certain bank has it. So once again, we're talking about the banks. Okay. Look, we're talking about when now come on now. We're talking about when they say you default on the loan. We're not talking about what you think or what you saying the loan is. I'm saying when the banks or the mortgage company tries to say that you have defaulted. It's not about what you did or not, but I'm saying what they're going to say you did. So you got to go along with what I'm saying. You can't. We're not talking about if what what you have to do as the argument. I'm saying defaulting on the loan in terms of mortgage and student loan people. They're going to say you defaulted. Okay. Now I don't care what you saying as far as what it is. I'm saying when the student loan people say they're going to say you defaulted. So you have to put that argument to the student loan people, which is kind of what I'm trying to get into. Okay. Because we know, look, that's the whole point. We already know that you paid for. Look, when y'all sign these promissory notes, y'all already paying it. It's already paid. The promissory note is a form of payment. Okay, so that's what the point is. But I ain't even got there yet. I mean, like I got to get there first, bro, before you start going in and all that stuff. But it says right here, uh, who commits promissory fraud? No fraud. See, this happens all the time. They sell illegitimate promissory notes directly to investors. See, what they do with your promissory note is they take it as payment, and then they take your promissory note to investors. So that's what they're doing with your. They're taking your promissory note, which is your promise to pay. That promissory note is a negotiable instrument. Okay, that negotiable instrument becomes like a check. They use that to pay to give it to the investors. So your student loan don't even be where it's supposed to be. Your mortgage don't even be where it's supposed to be because they didn't took their promissory note and then gave it to investors.
But
Okay,
this is the funny thing. In order for them to claim a detriment, a loss, where are they filing it on their taxes? Because nine times
you
out
say
of
what?
10, they listen. In order to claim it as a loss, right? They have to claim. Okay, let's say I got to. Let's say that I loan you some money, right? As a corporation, I got to file taxes on that. So this is what happens. The government is going to give me a tax credit, right? They're going to say, okay, we will give you a tax credit because you took a loss on that. So you don't have to pay taxes on that money. So either way, they got relief. The government paid them. If I say I took a loss due to consumers didn't pay me, what I do is I write that off on my taxes, right? As a loss. What do the government do? They say you don't have to pay on that loss. The only thing you have to pay on is what? Profits,
Right,
right?
right, right,
So the government already gave them a tax credit. This is why Either way, you win if you pull the taxes. Because either they're going to show they took a loss, which they got already a tax credit, or they're going to show that they made money off of your promissory note.
Exactly.
They have to file taxes on the money. If they don't file taxes, then where is the debt?
Right. You have to follow the taxes.
Corporations got to file taxes. I don't know what corporation that don't file taxes. They all must file taxes. Nobody is pulling up the tax record.
No, nobody's fool, and that's true because you got to follow the tax trail, like you said. I mean, like regardless, the money has to be taxed at some point,
All you
right? So you
gotta
have to follow the money,
all you
and that
gotta
makes
do
sense.
is just keep following the money. And then I told you already that like I said, if somebody said you signed a mortgage, the when the attorney present the claim, they got to have that exact person, that eyewitness you signed the document, or they failed to state a claim because they have no eyewitness.
Right? And you're right.
You see,
If and you would know who it is because you were there as a witness to it, so you saw who the person was there, right?
right? So you the only one in the other party that was there witnessed the document. How many times in the mortgage of default, people go in there and start arguing all of these different things? I would keep it simple. I would point out the obvious. I would file a motion to dismiss. I would look at the complaint. Who is the complaining party? They have somebody that's not associated with the loan. And then they won't even have the delegation of authority or the title or whatever. And you can be like, I ain't signed. They be like, well, he signed this mortgage. Well, bring the person in that identified me as signing this note. They can be like, well, in our office, well, was you present when I signed the contract? Well, I'm the president, or I'm the such and such uh, agent that could do. Was you present when the note was signed? Did you see me do anything? No. Okay. Case dismissed, Your Honor. They failed to state a claim. They don't have an eyewitness that can verify that I did anything. I'm asking that this case be moved, and that on the grounds be moved with prejudice, because they had time to prepare for this case, and they are a mortgage company. They should know how to do business. Simple.
Right. My man saying local, a GT saying motion to dismiss lack of standing, motion to dismiss failure to state a claim to which relief can be granted. And then he's saying motion to dismiss for lack of standing, which, right, lack of standing. They don't have any standing. They don't have any evidence. They don't have any claim. What's the words that we use? Not the claim, but vested interest.
Yeah.
They don't have vested interest in the
They
claim.
You got to think about this when you're dealing with all cases as it relates to everything. Somebody got to authenticate these records.
Right, like and you know another thing that the brother mentioned, and this is what I use too. Like with student loans, people coming up to you, what kind of accounting practices are they using? You know, there's a GAAP standard that's supposed to be used when you are accounting for any type of money. So, like he said, this accounting standard applies to mortgage as well as bank accounts, and it also applies to, like I said, student loans. Because a lot of times the student loans too is like a third party.
Accounting ain't nothing but same thing. We asking for documents. It's just keeping the records. A lot of
No,
we
no, right, right, right. We just saying like it's not, but we're just saying,
right.
they're different type of records. You got the tax, keep record of taxes. You got where I want to see where the money went. I want to see how y'all loan me this money. Can you show me how you allegedly gave me the money that I asked for? If I ask you for $10,000 and you just do nothing but take my promissory note to some investors and y'all cash it in and you give me the money, don't you think I need to know that?
And not only that, where is your cut? They took a promissory note, made money off of it, and
Yeah, yeah,
didn't even give you your cut. Yeah, we talked about a gap accounting,
yeah.
but
Guaranteed.
at the end of the day, when you ask for that in discovery, right, it's
Yeah,
it's gonna boil down to taxes. It's gonna boil down to show if they made any profit off of that, they didn't, because the only way that you could default on something if somebody didn't make no money off of it, right?
facts.
So if you say, if Vanderlei say, if I say, you say I didn't pay you, right? And I gave you a promissory note, and you took that promissory note. Let's say you gave me $500, and then I gave you the promissory note, and you made $10,000. Then you make your money and then some off the promissory note.
Facts.
So if you made your money, how do I owe you any money where you can't show that you took a loss? Because the whole purpose of the court is to make you whole, not to give you more money. It's to make you whole where you took a loss.
Exactly.
But see, they gonna go and see. This is the problem with all of that, because a lot of people do that accepted for value stuff, and then they try to turn it around. The problem with that is a lot of that don't work as a lot of people think. They say, well, they try to cash it. They say this is my deposit. They try to cash. They try to do everything they can with that.
You talking about like with the treasury account?
Now, like let's say you get a bill, like a like the mortgage or a gas electric bill. They say
Yeah,
that it's a positive amount. It's not a negative amount, and that is you supposed to accept it, and
yeah.
then
A for V. A for V, right?
A for B, separate for value. That's what a lot of people be trying to do. But the problem is, I never really seen it work the way people say it's gonna work.
I haven't either, man. I'm gonna keep it a buck with you. As much as I've studied it and seen it. I mean, over the past, I'm talking about almost 20 years. I've been hearing about A for V for almost 20 years, and I haven't seen really too many people do the A for V without. I don't know. I'm gonna say look over their shoulder because a lot of times that stuff is investigated. Right. They try to use it as coupon where I mean, really what we try to do is show remedy like that is going to be recognized by the court. I think because one thing about court, people think that the court system knows everything. A lot of people think the judges know it all, and they don't. The judges do not know what the hell be going on with the with a lot of these things that's going on because that's not what they're told. They're not taught that. They're taught to do it a certain way. And so when we go in there talking about certain stuff, you really have to, if you're trying to explain it to the judge, you're going to have to put it in a language in which they understand it.
The purpose of this, when you suing somebody, you must show damages or loss. If the bank cannot show where they took a loss, then because the court is only there to make them whole, to give you back what you lost.
Facts.
You're only there to be made whole. You can't. That will be considered unjust enrichment. So the bank is only there saying that we took a loss. So now they got to show the detriment.
Right. GT was like baby turd. Hey, you cracking me up, man. Yeah,
You see what I'm saying?
yeah.
That's it. So why go into all of these other things when you can just say, okay, prove that I default on the loan? Prove it. Okay, let's look at the tax. The tax is gonna tell it all. They got it, and then you got to look at the gap, right? We want to look at your accounting principles to determine how you came up with this detriment. Let's look at the taxes. You saying
Exactly.
you saying I missed the payment, but let's assess the taxes. That's all you got to do. Let's look at the taxes. The tax is going to tell it all. Inspect the evidence because they saying they lost. They took a loss. If the taxes do not reflect that they took a loss of any kind, then they failed to state a claim.
So my man, they'll say they'll breach the contract in terms of the note.
But the county won't have
County won't have the note on record.
a record, just a deed of trust. Normally they don't say, they say you defaulted on the mortgage. And they don't normally use the term breach of the contract. But in order for you to breach the contract, once again, the bank must show they took a loss.
Said the bank must show that they took a loss. Now hold on, he's saying that there's no note, right? But doesn't the bank got the note?
The bank then sold the note. The note been sold probably about 10 times. They done made their money and then some.
Right, but they got a copy of the note.
Yeah, but it's not the original note. They just got a copy. And it's not probably an authenticated copy either.
I wouldn't say that. I wouldn't say it's an authenticated copy. I would say it's a certified copy of the original.
Now, what I'm saying to you, in order for it to be authenticated, right, as the original.
Right. He's trying to say that the more, but I'm saying but listen to what I'm saying, GT. If the bank has the note or a certified copy of the note, and then all they got to do is get a copy of the deed of trust from the county recorder office. So they got a copy of the note on record, a certified copy, and they got a trust deed from the county recorder office. It's a trust deed on the county recorder office. You just said it. It says you just said right here. You just said here that there's a breach of the contract of terms of the note, but the county won't have the note on record, just the deed of trust. So what I'm saying is the county got the deed of trust. So you go to the county recorder office or the county, wherever on the county level, get a record of the deed of trust, and then the bank has a certified copy of the note. You think the bank ain't gonna make a copy of the note before they send it off to somebody else? Y'all foolish. Y'all foolish. If let me ask you something, Gigi, if you don't think that they ain't made a copy, then you foolish. Very foolish.
But if they made a copy, it has to be a certified copy, meaning it has to be
He said
authentic.
they go to. He said they go together.
They
I
do
mean,
go.
like what? They on the right? Are they on the same page? Are they? I mean, I'm saying they can't be separated. I
Yeah,
mean,
you can. I mean, you can
tell
do it.
me.
Yeah, you can
I'm
do
just
it
saying.
that
I'm just saying.
way.
So I'm just saying, if they separated, put one on record at the county recorder office, they got a record of the. They got a record of the mortgage and the dang on copy of the deed at the bank,
There's
because
no
the bank originally had the deed, right? I mean, not the deed, but the
mortgage.
bank, the note. They
The
had the
law.
note. If the bank originally had it, they got a copy somewhere. Now you might be able to argue if that copy is certified, but they're going to have a copy. You can't tell me. Its court cases already won because the note and the deed were uh what's that, bifurcated or separated. All right, show us some case law where they've been able to do that.
But I think
Because
when he's talking about it's already BC, when you use the term bifurcated, what do we mean? Because bifurcated normally mean the case already been decided.
what I'm saying is, show me a case law where they didn't have the things together, and that because it wasn't together, it was automatically it was dismissed or whatever it was. So that's what I'm saying. So what? It's not the original. I get that, but what I'm trying to tell you is they have a certified copy of the original. Is the judge are going to accept as evidence a certified copy of the original? I don't. I mean, you tell me. I mean, I'm just saying. Like, what we do here is King know how I get down. Like, I'm gonna get into the nook and cranny of this because we could throw stuff out there and say this and that, but I gotta it gotta make sense. It gotta make sense all the way around. So I'm just saying, like, you you know the bank is gonna have a certified copy or have some kind of copy. If it ain't certified, you definitely got an argument. But they gonna try to have some kind of certified copy of the original. They gonna try to have an affidavit saying that this is a copy of the original document.
But the problem is, it still has to be authenticated.
I'm saying no to what? Like, how you say no? How you tell me? How are you trying to tell me that the bank don't have a copy? Are you telling me the bank that's stupid? Is that
They,
what y'all telling me? I mean, I'm telling me, King. I mean, I'm asking you, King. I'm
no,
asking you,
they
King.
do know
Is
they
the
got a
bank that
copy.
stupid?
No, they got a copy. They got a copy. That ain't the issue. That's why I say we're going there arguing frivolous things. They got a copy. It just has to be authenticated. And what do I mean by authenticated? Right? So if a bank got a certified copy of it, the only person that the two people that signed the document must name be on the certified copy.
How is it going, to man? Hold on. He said, I'm about to. What the heck is
You
going
say,
on?
well, it don't matter.
Yeah, he was saying it really don't matter that they got a copy. I don't see how it don't matter if they got a certified copy. I mean, they gonna try it. I want to know what your argument is against a certified
But,
copy.
but the thing about it is, they could try to say is it has to be authenticated. The record has to be authenticated. So this is what I'm talking about, arguing frivolous things, right? He's saying, okay, we're talking about the copy.
Yeah, I'm gonna put
But
this in here about bifurcate law. I think you sent this to me too. I'm gonna put it on the screen.
I put it in the it says means bisect, halve, divided, split, cut in two, cleaves. In a legal sense, bifurcated, bifurcate refers to an order or ruling of a judge that's already been determined.
Yeah, the second part.
An
Right.
issue, a case can be separately tried to a conclusion. It's already been concluded. A judgment rendered on one aspect of the case. The county
My fault.
records that
Oh,
only
my fault. It said determination of all. My fault.
it said the county
I meant to hit that.
records, they only place of identification is a county court.
Yeah, he trying to say that. I'm like, hold on, bro. I'm gonna go back. Hold on. The only place, the only he's saying the only records, the county records, the only place of authentication in a county court. Hold on. Excuse me, send a certified copy or an authenticated copy. You telling me that you can't get a copy authenticated outside of the county court?
Mm.
Right. We know the county court authenticate records, but they authenticate them. They don't put them on record. Like you can go down there and get something authenticated, and it's not
This
on
is what
record
I'm
per
talking
se.
about. We arguing frivolous things. Vanilla,
Yeah.
this is what I'm saying to you. We arguing. Okay, he's talking about the record, only place they can authenticate a copy, right? So
Yeah.
the
I
authentication,
agree.
so the authentication process is the notary. Only thing they're authenticating is the notary is a true notary. That's the only thing they're authenticating, right?
Facts. Correct.
So, but the contract itself, the two parties can only authenticate the contract itself. Me and you who signed the contract has to authenticate our signature. The notary has to acknowledge that we both did sign the contract, authenticating that that is our signature.
I mean, it's like this. It's like he's saying that we don't get it because we don't agree. You know what I mean? Like I get what you're saying, and it's not against that. I'm okay. You don't know me, but I'm gonna poke holes in everybody's stuff. Like if you're telling me one thing, just because you telling me don't mean it's true. I don't even know who you are for real. Like you just, you know what I'm saying? You got a name now that ain't even your name. So I'm supposed to, I'm listening to what you're saying. We here listening, and we try to break it down, but I mean, I need you to make more sense of that because you're acting like we don't get it. No, you need to make more sense of it because you're trying to tell us that they don't have a copy
I was just
that they
dealing with somebody who the bank brought a copy of the note. They found the note on the record.
so all we doing is trying to make sense of it. If you say something and we don't agree, we might have a statement on it. I mean, a lot of what you're saying makes sense. I'm not even saying that I don't even understand all of it, but what I'm saying is there are some other things that are going to be talked about and discussed.
I'm
So I'm saying like, right. So we're saying like, okay, if it's only on the county record, right, and the only thing that's on the county record is the deed, the trust deed. You're trying to make the argument that they don't have a bank note, but the bank note originally, the bank had the bank had the note. They probably got a copy somewhere, and we're just saying like these are some of the things that you got to think about when we saying all this stuff. You see what I'm saying? And I'm saying right, but I'm saying If you say sometimes the notes on record, sometimes it's not, then that's what we said. I mean, you said no, the notes never on. You were saying no, the notes not on record. Then now you say it could be on record, and that's all we saying. It's like, well, it could be on record if the bank made a copy of it. We not. I'm not trying to like go against it, but I'm saying like I'm thinking about everything that's going on, and I'm thinking like why they wouldn't have it on record because they just think they got it like that. But if you say it is like all I can do is take your word for it that they don't have it. I don't know. I mean, like King. I mean, do you think that the majority of banks have a certified copy on record?
Yeah.
Okay, so I mean that's what I'm saying, and I get it.
But this is why. But see, I try to make it simple, stuff that's easy to point out. They can bring out a. They can bring out. They do this stuff all the time. They can say, "Well, we got a certified copy of the note, right? We got a certified. What makes it a certified or a authenticated record? Because only the parties to the contract can authenticate it. The notary who sealed it say that these two people did that, but you have to still have the party come in and testify to the contract. This is why if you file a notary by itself, it won't stand unless the person is there who the affiant who made the affidavit to testify to the affidavit. You just authenticating that the notary is a true notary, and that's it. The state can say, well, the person who did this was authorized to be a notary, but they still want you to come in and testify.
I got you. I
That's
mean, and
why.
I got. I just felt like it's more than one way to do it, and you want to cover if you want to cover yourself, you may because like you said, some of them might not have the note, some of them might have the note. I'm saying you don't know if they do or not. And so you probably need to prepare just in case they did to have a higher argument. And that's like he said, we talking about the affidavit. I don't think there's nothing wrong with what you're saying, but I don't think there's nothing wrong with what we're saying as well. Like if you're trying to get, if you have an affidavit that you have to verify that it's been that person has to be there to show that. That's definitely another way of attacking the problem because there's more than one way to attack it.
I just like
And
to
so,
point out the obvious. I just try to tell people, kids, keep it simple. Just keep it simple. The more convoluted you make it by making certain arguments, like I said, they lack standing because why? They got to have a person that identified you signing that document and that you were the one on the contract and that is your signature. Anything the lawyer presents is hearsay evidence without an affidavit in support of the complaint as relates to a witness testimony. So they got to bring the witness in. You have a right to confront your accuser. So if somebody wrote out an affidavit saying you did something, they have to come and testify to that you signed the note.
I
And it
got you.
and it can't be nobody else from another department that has authority to enforce that because they did not see you sign the note. That's
Right, I
why
got you.
you can subpoena the notary in because the notary act as a witness and say, yeah, I witnessed that. I wrote it down in my journal that they on this day they did this action. I got their name and all of that. That's why I'm saying let's make this simple. Not arguing, about it. Let's just try to point out the obvious so people can get a remedy so they don't have to argue about things that's frivolous. And like I said, the bank is there only to be made whole. The only thing the court is there is to try to make somebody as whole as possible, right? That's it. If you had a car accident, you tore up your car, the person gonna fix your car, right? Put your car back into the shape it was before it got hit. That's it.
Fact.
You can't go and ask for $20 million for a car accident.
Facts. Facts. And so, and I get that, man. I wanted just like I said, I mean, we're talking about mortgages and student loans, but I know we've kind of gotten pretty much stuck on the student. I mean, stuck on the mortgage side, and I did want to finish up what I was saying a little bit on here in regard. I just wanted to paint a picture of what the student loan debt is because, like I said, the student loan thing is a major thing going on right now, along with mortgage. The mortgage thing been an issue, and the promissory note is used for so many different things, right? Is it popping up or not? Well, it may not pop up, but I'm going to read this. It's saying that Americans, oh, there we go. Americans owed a collective of $1.71 trillion in student loan debt as of December 2020, according to the what Federal Reserve. By comparison, in December 2010, Americans owed about 845 billion in student loan debt, which means student loans debt has increased by over 102% in the last 10 years. Okay, so a lot of the debt that is being held on Americans is student loans. It says, according to the U.S. Department of Education, 42.9 million Americans held outstanding student loan debt at the end of 2020, or about 17% of the adult population. 75% of students with student loan debt went to a 2 4 year college, and the remaining 25% also borrowed for graduate school. And about 6% of the people with school student loans debt owe more than 100,000. This group accounts for about a third of all outstanding student loan debt. Okay, this stuff is crazy because what they've been, this is a scam because they've been, telling you that everybody's got a right to education, and then they've been telling you everybody, you know, you can go out here and get a degree. They're pushing for education, and they throwing this money at you. You guys think about this. You guys are getting these loans based on no credit checks or anything, right? Like not even like a regular loan would be, even though a regular loan is screwed up. But the student loan debt is more screwed up than any other loans. They screwed up more than any of these other loans. The New York Federal Reserve reported about 11% of student loan debt payments were either late or in default. And that's what I meant. Like they say the word default. I'm not saying that it's in default. Okay, so that's what I'm saying. Like don't come at, I'm saying what they're saying is default. It says by all indications of this, all the indications, this debt and late payment and defaults as well will continue to rise. So it's a major issue because it's all this promissory notes out here that these guys have put out here. Okay, they done took all your student loan debt, all your promissory notes, they done gave them to these investors, and it's all out here circulating. And they done created money for the future to use now. And so there's going to be a point when somebody's going to be like, "Hey, we need that money real quick." You know what I'm saying? They're going to need that money real quick, and it's going to crash. It's going the shit gonna crash on them, and then everybody gonna be scrambling, right? So what my man saying? He's saying that treatment of credit balances, account termination. Okay, I got you. And what's this in? This is what is this in the is this in the what in what book? CFR? Is it in uh, USC? Is this USC's? Is this CFRs? Is this that we can give this to the people? Because I mean, like I said, this is all we here for educating, and we can all educate each other. And so I'm not against it, but I will. Me, I'm a question and put everything to the test. My brother King Abe, no, I'm always questioning everything that's being said so that I can get a better understanding, and also just to see if it really stand on what it stands. So, uh, okay. No, I was just saying, like, if you, all right, let me look it up then real quick. If I can copy this. Oh, okay, that's what I was saying. Consumer law. That's all I was trying to look. Yeah, I'll look it up, brother. I just didn't know where to look. So I'll look up consumer law and see what it say. 10/26/11. All right, let's look. And everybody, like I said, like the video, subscribe. Let's look at it. Let's see what it say. If I can pull it up. Oh, okay. Yeah. So I'm gonna pull this up and I'm gonna pull it up and share the screen. I gotta share the screen again. Share the screen again. And see what all right, treatment of credit balance. All right, let's look at this and break this down, y'all. Let's break this down. Let's say 10/26/11 treatment of credit balances. Account. When a balance credit is less, excuse me, balance in excess of $1 is created on a credit account through transmittal of funds to a creditor in excess of the total balance due on an account through rebates of unearned finance charges or insurance premiums or through amounts otherwise owed to or held for the benefit of the consumer, the creditor shall credit the amount of the credit balance to the consumer's account, refund any part of the remaining balance within 7 business days from a written receipt or request from the consumer, make a good faith effort to refund to the consumer by cash, check, or money order or credit to a deposit account of the consumer any part of the credit balance remaining in the amount of for more than 6 months. No further action is required for the consumer's current location is not known to the creditor and cannot be traced through the consumer's last known address or telephone number. Okay. All right. So um, I read that off. Right. It's a CF. No, what I mean, like, okay, so I just got it. I just read that. And so you're referring that to, so are you referring that back to the mortgage? And I read it, I'll read it again for everybody, but just let me know what you're trying to convey when you say that, when you got that. Because I get what you're saying, the term treatment of credit balances, account terminations, Financial Protections Bureau. How would you use this statute in relation to um, a student loan or a mortgage? Timely settlement of estate debts for credit card accounts under, okay. So I'm just trying to see what you going with that in regards to what we're talking about. Right. No, I mean, I want you to give me an account of it. I put that up there for your, so you can help prove your point. Because, like I said, I mean, I ain't against what you're saying. I just want to get full understanding because this is going out for everybody. You know what I mean? Like, who gonna watch it later and check it out? They need to understand what is going on, and we just trying to give remedies that we know we can stand on, that we know that they can't prove. So, uh, with disregard, okay, now that the truth in lending, the truth in lending is, let me put that up here so I can look at it. I'm gonna put that up here. Truth in lending. Yeah, hold on. I thought I put it up there. Okay, there we go. All right, I'm gonna put this up here and then I'm gonna look it up. And I've seen this. Okay, let me put that up there. In fact, I think King was looking at this the other day. All right, so we got the truth in lending.
I also want to say something about the truth and lending that
Go
truth
ahead.
is not necessarily a fact. So when you look at the rules of evidence, they're dealing facts. A truth, me and you can see the same thing and tell our own truth, but it doesn't mean that they are factual. There's a difference between a fact and a truth. A fact is something that a group of people consider that that is undeniable. But
Okay.
truth can be. That's why I try to tell people these people are very deceptive in what they're doing. So if you look at the rules of evidence compared to the Truth in Lending Act, what is these people really conveying? All I do is I can say, well, um, I can see something that I can think is the truth, and it can have some errors in it, or it can have some omissions in it, right?
Right. I mean, it's
But
good information though, just for
but
people to have.
but that's my truth, right? But if we gonna deal in facts, look to the rules of evidence because it explains what of something, how something can be considered evidence. We're looking at evidential standards. as it relates to the Truth and Lending Act, you must compare it to the evidentiary standard as what is considered evidence. So let's say Bob come in there, he say, "Well, I seen that guy come in and he was saying he was going to sign his mortgage agreement today, and I seen him went in the room with Tony, right? And but he didn't see you actually sign the mortgage, right? He can put in an affidavit saying I seen you walk into the bank saying that you was going to sign the mortgage agreement, but he can't authenticate that you actually signed the mortgage. Only the person that eyeballed you, eyewitness you. That's why you always need what they call a eyewitness. Always need to come forth. He said, "Don't leave the page." So go over that.
Put a scroll, click right, go to. I didn't. My fault though. Your comments didn't pop up. I couldn't see them, man. So you want me to go back up to the top of the page? Uh, Hold on, let me go back.
A lot of people use that Truth in Lending Act.
Like, am I going back to table of contents? Okay, I'm back at the top of the page. Now, where you want me to go? Cause I couldn't see your comments, bro. Like it's weird. Your comments are all like not there. I don't get. I don't know what's going on. It's like my computer is bugging, man. I'm trying to tell you. Like it'll pop up here in a minute. I guess. Give me time. I don't know. Like I said, something's going on. It's like slow, so I can't even see like any of your comments. And then it pops up. So everything is. I don't know. My computer be tripping, man. My computer be tripping. But see, that's why I want you to come on. Now, what did they? What did that say? Oh, okay. So you want me to read that first part? I mean, you can read it. It says the authority. This part known as Regulation Z is issued by the Bureau of Consumer Financial Protections to implement the Federal Truth in Lending Act, which is contained in Title One of the Consumer Credit Protection Act, which we kind of went over this before as amended. This part also implements Section 1204 of the Competitive Equality Banking Act of 1987. Okay. Furthermore, this part implements certain provisions of the Real Estate Settlement Procedures Act. And in addition, this part implements certain provisions of the Financial Institution Reform, Recovery, and Enforcement Act. Oh, these goddamn acts. And it says this Bureau's information collection requirements contained in this part have been approved by the Office of Management Budget under the provisions of 44 USC and has been assigned by OMB. Okay, okay. So you can show the authority. I mean, like, I think this is. I'm not gonna go all the way into this because I mean I think we about to get off this live, but for everybody who's coming in on this, I am. Uh, you good? You found okay. It said yeah, you found it. Everything that everything here is, I think, something for everybody to read. Like this is good for studying because most people don't look here for this part. I think we did a video where we did go into this, and we do go into the CR. We do go into this a lot. We do go to this site, the Consumer Financial Protection Bureau. This is the spot. I ain't gonna lie. Like this is where you do a lot of your fighting because they'll do an investigation for you on your behalf. You right? So, um, but you know,
Could I add a quick note? That's why a
oh,
lot of us don't supposed to be in court. The agencies, we supposed to file complaints And that's what the agencies are there for, to make sure that all of these private entities stay in check. So when all of these agencies are out of compliance, you're supposed to file a complaint with the agency to make the determination, right? If the
Right?
bank is in compliance with state and federal law. 9 times out of 10, it's going to start with the federal law. So you do the governing body as you do like Freedom of Information Acts before you go to trial, before you even get to court. You start collecting and building all of this stuff up. Especially if you don't, if you guys gonna try to get a house and not pay for it, at least do all your due diligence prior to defaulting on the loan. Get the Freedom of Information Act, get all the stuff that's necessary, file a complaint with the agencies to all the proper authorities, then default on the loan. Don't wait till after the fact. Wait till you get ready. You want to already have your ammunition so when you go to court.
Facts. 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 And that's true. I mean, and that's what I got a video on that, and we using the you use that agency. You use the Consumer Financial Protection Bureau. You use that agency to make a complaint, to do the investigation. They come up with their findings, and then they can make a determination from there. A lot of times, because they make a determination in your favor, that's pretty much the end of it. Like you got it. But even if it's not, that's a record that's going to be able to be used in court. So I mean, like you definitely got to use your administrative. I call it your administrative tools. Like these are your administrative tools to use in order to um, rectify or deal with a situation and not even have to deal with all that court stuff. Because once it goes to court, it just gets messy. So look, you really want to try to deal with this and fight them outside of court
Well,
and
if
have them settle. I mean,
so, I'm gonna reiterate what you said, right? That they call them fact finding tools as it relates to the rules of evidence. If you know you're gonna gotta, if you know that you planning on that, that's what you're going to do. That you're going to go to court. Have all your ducks in a row. Don't wait till the last minute. Already have the case beat before you even walk into the courtroom. Already have all the necessary things played out and put forth. Have it already laid your cards where they know you got a royal flush. You feel me? Don't wait till you is going to the court and have to file all of this, because more than likely these people are already gonna beat you to the punch and trying to move on this case. And a lot of people is just not sufficient or thorough enough. So if you plan on doing all this stuff and saying that the fraud, and just have all your ducks in a row before you even get to court. Have your royal flush in your hand. So when it comes down to the bargaining table while you in court, you already got the game won. You already know what it is. Do not wait to the last minute and think you're gonna beat these people. These people been playing this game a lot longer than you. They're more better at it, and the court tend to work with them because they are the financial institution, and the court make money. Y'all got to remember, this is a business. Don't take it personal. It's only business. So if you're not business savvy and you say, well, I ain't going to pay my mortgage because I think it's fraud, go ahead and file all the necessary complaints. Do all the necessary things prior to. Have all your ducks in a row. Do everything that you need to do And so when you don't pay your mortgage, you can say this is why. That it's already been satisfied or whatever, and that the bank know you got them by the tail, and they're not going to waste time trying to file when you can just send them a letter and get it all over with when you know you got them in their head up under the water. And that's the problem. Everybody
Facts.
wait to the last minute. They're not doing their due diligence. And my house is already paid for. All my bills is already paid. Do your homework first. Get it all set up. Cause I'm gonna tell you, if you don't know what you're doing, you're gonna lose on the end. That's all I got to say.
Well, with that being said, man, that's pretty much it, man. Appreciate everybody, and we're gonna get up out of here. So until next time, y'all.
Peace, family.
Peace, peace. Tuta Nana.